And now let's come to see what the other institutional rules say. For instance, the ICC rules says that the arbitral tribunal not only needs to establish the provisional timetable upon its formation, they also needs to get a so-called terms of reference drawn up and signed within 30 days upon receiving the case files from the Secretariat. The terms of reference is a document that includes, for instance, particulars of the parties and arbitrators, the place of arbitration, a summary of the party's case, particulars of the applicable procedural rules, and perhaps a list of issues to be decided by the tribunal. In practice, the terms of reference also include, for instance, jurisdiction challenge, if there is any, procedural history that led up to the preparation of the documents, an arbitration agreement, and sometimes would also include the provisional timetable as an appendix to the terms of reference. So although the terms of reference is a particular document required under the ICC rules, in practice, for ad hoc and other institutional arbitration, many arbitrators they may still prepare and install such a document simply for good order reason, but preconditioned that it is not prohibited by the applicable arbitration rules. Now let's come to the third part, the initial procedural meeting. In reality, before establishing the provisional timetable, the arbitral tribunal they often needs to conduct one or more preliminary procedural meetings in order to, among others, to get to know the participants of the arbitration, just to get familiar with each other, to introduce each other, and to discuss how the proceeding should be conducted, which evidence rules should be applied, and whether there is particular confidentiality issues, and the main items under the provisional timetable, including, for instance, the evidentiary hearing. So the initial procedural meeting, or the so-called case management conference under other arbitration rules, while the uncentral rules did not provide specifications for such initial meeting, the ICC rules and other prevailing institution rules, such as the Singapore International Arbitration Center rules, they require that a preliminary procedure meeting be conducted at early stage of the arbitration. Article 24, paragraph 1 of the ICC rules require that the arbitral tribunal shall convene a case management conference to consult the parties on procedural measures that may be adopted in the arbitration, and the tribunal may conduct further case management conference to adopt further procedure measures or to modify the timetable. Such case management conference could be conducted in person, by video conference, by telephone conference, or similar means of communication. And similarly, Article 19.3 of the SIAC rules requires that the tribunal shall conduct a preliminary meeting with the parties in person or by other means to discuss the procedures that will be most appropriate and efficient for the case. So in summary, the case management conference or the initial or preliminary procedural meeting is designed for the arbitral tribunal to discuss with the parties about the best procedure for the arbitration, while taking into consideration the values of fairness and efficiency. In practice, very experienced arbitrators, they will always prepare and send out an agenda, or they invite the parties to prepare an agenda for the initial procedural meeting, and they will set out the items that they would like to discuss with the parties during the case management conference. And such agenda often includes, for instance, discussion of the draft provisional timetable, suggested timelines for submissions, suggested dates for hearings, and terms of reference if it is applicable, and comments and execution of that document, or procedure orders, or submission timelines. It is continental style memorials, or it is common law style pleadings. Where should the hearing take place? What should be the language used in the arbitration, and what should be the language used for submissions and for evidence, and whether there is any challenge of a member of the tribunal, what evidence rules can be applied, whether the IBA rules on taking of evidence should be discussed about, or should there be discovery process, whether there is jurisdictional issues to be discussed about. So these are all the possible items to be discussed during a case management conference at the very early stage of an arbitration. So you can see that there are many things to discuss about during this meeting. And it is often customary that the presiding arbitrator, they often lead the meeting, and they will invite first the parties to comment and respond to each item on the agenda. And then they will try to settle on the common ground for each item. And if there is difference on a specific item, they will often reserve it for future discussion or reserve it for a written exchange after the meeting. And for counsel of each party, they often need to prepare in advance of the procedural meeting. For instance, they will need to consult with his or her clients on available dates for hearing, on their preferred style of submissions. During this stage, there could be extensive amount of work incurred by the counsel, and during the meeting, the counsel of each party, they may disagree with each other, which is quite frequently. They will try to get the most favorable procedural arrangement for their client, although sometimes it is not so obvious whether a choice for one procedural arrangement has benefit for their client or not. However, from the tribunal's perspective, they often settle on the common grounds that have already been reached by the parties. They will only decide on the procedural issues that cannot be agreed upon. The tribunal often encourages the parties to use their best efforts and from the spirit of good faith to reach common grounds so that they could reduce the cost in these procedural matters. The most frequently disputed procedural items could be the timeline allocated to each party to make their written submissions. In many cases, the claimant and respondent, they both want more time and more opportunity allocated to their submission. However, the tribunal they often needs to strike a proper balance, such as allowing 4 weeks to claimant for submission of statement of claim, and perhaps 4 or 5 weeks to a respondent for submission of statement of defense and counterclaim.